Before starting this session, I humbly request to the delegates and listeners, kindly switch off your mobile phone or put in the silent mode. Now I would like to invite on the dais Mr. R.K.P. Shankardass to come on the dais, please. Mr. Honorable Justice Ajit Prakash Shah Sahab, Mr. Amarjit Singh Chanjok Sahab, Mr. Tejas Karia Sahab, Mr. Rajiv Datta Sahab, and I request to Justice to chair this session and start this session. Mr. Shankardass Shah Sahab is to chair the session.
Ladies and gentlemen and friends, we are being called upon to start now immediately. We have a very distinguished panel here today. As you can see, we have perhaps the most illustrious Chief Justice, the Delhi High Court. He came to us and changed the face of, made many changes which we still relish and use and follow. He was, as you know, also one of the possible one of the possibilities was that he would go up to the Supreme Court as well, but as it happened, it didn't work out, and we in a sense, it's a regret which I think most members of the bar still have, that for whatever reason. But it's good to have him. He is, apart from being from Bombay, Chief Justice Madras, then Chief Justice Delhi, and of course now in the Law Commission as its chairman. So we are very happy that he is in that place, and we hope that his recommendations will carry weight, and that some of the amendments that are law have been long overdue will now be implemented, or seriously considered and implemented. We have with us Mr. Amarjit Singh Chanjok. He's many things, former, now a very eminent lawyer, but before that he was president of the Delhi High Court Bar Association for a number of years, for the additional Solicitor General, and during this period he did, as we all know, achieve eminence of a kind that we all have recognized. We have Tejas Karia, who was, I'll come back to this side in a minute. Tejas Karia, who's much probably younger than all of us, but a very hard-working lawyer from Amarchand Mangal Das, and both Mr. Chanjok and Mr. Tejas Karia have been associated, I'm told, with the work of amendments in the Arbitration Act over a period of time. And therefore, Justice Shah tells me, unfortunately he has to leave after he has made his presentation, but he tells me that these two gentlemen, Tejas in particular, will be able to answer any question after he has answered some of them that he is able to, when he has finished his speech. We have, of course, Mr. Rajiv Datta from the Supreme Court of India, senior advocate, a long-time friend, and of course, we have Mr. Rehan, who's going to look after us and make sure that we stay on the straight line. May I now, therefore, start off? I don't particularly feel because Justice Shah is in a hurry as well, so I'm not going to make any comments of my own to begin with, except to say that one of the causes that I have been following for a long time is to and making an appeal wherever I have public speaking opportunity suggest that lawyers should not encourage the inclusion of judges as retired judges as arbitrators, in fact they should make certain, look at the nature of the arbitration, the nature of the dispute, or which might arise in the case of any of the clients, and if there is an agreement, to ensure that an expert will be there, at least one of the persons who really understands the industry or the business or whatever kind of relationship it is, that is made an arbitrator, because you will hear more about it, but we've had, I personally have been in arbitrations that have gone on and have formed this particular opinion that we should not subscribe to what is nowadays, and was yesterday described as arbitration in India as an industry for retired judges. So that is something we have to get away from. And I don't want to say very much more. May I now respectfully invite Honorable Justice Shah to begin his presentation. Sorry.
A very good afternoon to Mr. Shankardass, distinguished speakers, and ladies and gentlemen present today. It's really a privilege to be amongst you and speak on the vital subject of roadmap to a world-class arbitration system. Ladies and gentlemen, there has been significant increase in international trade over the last few decades, which has been accompanied by a considerable increase in the number of commercial disputes as well. In India also, the rapid globalization of the economy has been accompanied by a very big rise in the number of commercial disputes. Such rapid development means increased caseload of already outburdened courts, adding to the problem of already very slow adjudication of commercial disputes. As a result, alternative dispute resolution mechanisms have become very important even for the companies in India as well as those abroad who are doing business with India. Unfortunately, ladies and gentlemen, arbitration law as is practiced and applied in India has caused much debate. Judicial pronounced disappointment was evident in the decision of the Supreme Court way back in 1981 in Guru Nanak Foundation versus Ratan Singh and Sons, when the court said the way in which the proceeding under this act are conducted and without an exception challenge in courts has made lawyers laugh and legal philosophers weep. A Bombay judge commented upon the proceeding under the new act that the lawyers laughing all the way to the bank. So it's really a very disappointment of the arbitration community in India. And it was in this background the subsequent act of 1996 was conceived and later enacted by the Supreme Court. Unfortunately, the experience is that the situation has not changed too much from the days of the old Act of 1940. The 1996 Act, despite being forced in for almost 2 decades, and despite arbitration emerging as a frequently chosen alternative to litigation, it has come to be afflicted with various problems, including those of high cost delays, making it no better than earlier the earlier act that it sought to replace or to litigation to which it intends to provide an alternative. Unfortunately, the arbitrations are usually treated in the same manner as traditional litigations, and arbitrators are willing to give long and frequent adjournments as and when they are sought by the lawyers. See, it has becoming a replica of the court litigation. Even the even the parties, I find sometimes, they approach the arbitration with similar mindset as they would approach litigations, with the awards invariably ending up being challenged in courts. Such challenges to the award again, they are made under section 34, and the decree becomes inexecutable, and the petitions are remain pending for years together. Somebody very caustically remarked that there are only two categories of people benefited by arbitration in India, that is retired judges and the lawyers. So, and I entirely agree with Mr. Shankardass that we have to first think we must change the arbitration culture. You see, outside I do not find that the arbitration is so dominated by the retired judges. Of course, there are very distinguished retired judges who act as arbitrators, but in most of the countries, the lawyers are the preferred arbitrators. Lawyers are preferred than the judges, and then surely we should have the experts on the arbitral tribunal, depending upon the subject of the arbitration. So, as a result of this, India, as of today, is not seen as a preferred international arbitration. I would give 3 reasons for that. To sum up my comment on the existing law. First is the excessive judicial interventions. There are some very inconsistent and contradictory judgments of the Supreme Court on the interpretation of the arbitration law. Second is the delays and high costs. The third is the difficulty in enforcing both domestic and arbitration awards, and the subjective grounds of appeal based on the public policy, because public policy is interpreted very broadly in Saw Pipe's case. So therefore, the Commission felt that it is necessary to revise the provisions of the Act to deal with the problems frequently arise in the arbitrations. And then the Commission has come out with the 246th report on amendments to the Arbitration and Conciliation Act 1996. And I would like to tell you about some significant amendments which are suggested by the Law Commission. Let me start with the complaint of practically everyone of the excessive judicial intervention in the arbitration proceedings. That is, judiciary vis-a-vis the arbitration. Ladies and gentlemen, it is thought in some quarters, particularly the business community, that judicial intervention is anathema to arbitration. The Law Commission does not subscribe to this view, I must tell you, and rather recognizes that judicial machinery provides essential support for the arbitral process. There is a very beautiful comment by Professor Jan Paulson. He was in India last year, and he described the situation as a paradox that seeks the cooperation of the very courts from which it wants to free itself. Essentially you need the support of the courts. Without the court support, arbitration would not work. And Lord Mustill really, he puts it in a very correct perspective when he wrote a foreword to O.P. Malhotra's book on the Indian arbitration law. He said, "It is no good complaining that judges should keep right out of arbitration, for arbitration cannot flourish unless they are ready and waiting at the door, rarely allowed into the room. So the parties and the arbitrators be aware that the court is waiting there. If there is a violation of law, the court is going to strike, but it's rarely allowed in the room. There should be rare intervention by the court." And finally he says, the courts must be partners, not superiors or antagonists in a process which is vital to commerce at home and abroad. One of the main problems of the arbitration is the delays in courts and before the tribunal. So, according to Commission, there are primarily 2 reasons for such delays. First is naturally judicial system is overburdened and is not sufficiently efficient to dispose of cases. And the second is, in spite of the bar of Section 5, the court interventions are far and too many. Now the Law Commission has therefore, I will just give the proposals for the separately for dealing with the question of delays and at the both at the arbitration level and the courts level. First, we recommended that there should be dedicated benches in all the high courts across the country for arbitration matters. Then the next suggestion is to restrict these frivolous proceedings or dilatory tactics. There is a proposal to impose actual cost. We have provided now that the rule, ordinarily the rule should be cost must follow the event. If the party is unsuccessful, it must pay the entire cost of the actual cost of the other side. Then 11, we have now recommended that instead of Chief Justice, a persona designata, it should be high courts at the Supreme Court. However, we have provided that suppose if the court says that directs somebody to appoint the arbitrator, it will not be regarded as a judicial act, because this was unintended consequence of SBP versus Patel engineers, because the court says it's a judicial power, so it cannot be delegated. So how do you reconcile this with Section 11, which says that the court can direct an outside agency to appoint an arbitrator? Then we have suggested a further amendment to that the Section 11 proceeding should be disposed of within 60 days from the service of notice. And I shall show you that now the Section 11 proceedings are made are simplified, and the scope is very limited. And 34 and 48, that is 48 is about the foreign award, we said that it should be disposed of within a year. Then other suggestion is that as far as international commercial arbitrations are concerned, the court will be only the High Court, whether the High Court has a original jurisdiction or not, but the matter will go only to the High Court. It will not go to the district courts. That's too much of a long litigation. So it will be considered only at the High Court stage and perhaps an appeal to the Supreme Court. Now, why this is necessary? Look what happened in White Industries case. That was a case where a foreign party got an award, and it was challenged in Calcutta High Court. The successful party objected to the jurisdiction of Calcutta High Court, and that was decided against that party in 2002. The matter went to Supreme Court in 2004. Since 2004 till today, the matter is pending in the Supreme Court. As a result, the investor, the successful party, moved BIT arbitration and sought a huge award against the government of India for the failure of the courts to decide the case within time. So I think 10 years is a too long a time to decide an appeal arising out of a jurisdictional issue. So therefore, we said that it should be within it should be High Court and then the Supreme Court, and should be decided as early as possible. Then under Section 48, when there is a foreign award, enforcement of foreign award, the objections are to be filed. Now, the experience is that they take their own time for filing objections. We have provided a limitation for filing objections. So it is 90 days plus 30 days. If you don't file objections, then the right stands forfeited. Then the other issue is, it is necessary to increase the threshold for the judicial intervention. Now, when the courts intervene in the arbitration matter, there are two stages. First is the pre-arbitral stage, that is Section 8 and 11, and the second is the post-arbitration, that is Section 34, post-award, I'm sorry, Section 34 and Section 48. Now, the Section 11 was interpreted by the Supreme Court time and again. Unfortunately, the court was more concerned with the nature of the power, whether it's a judicial power or it's an administrative power. But as a result, the scope of the power was not really addressed till the Justice Ravindran wrote the judgment in Bobara, National Insurance Company versus Bogara Polyfab, and still there is not much clarity. Now, what the Commission has recommended, that at Section 11 stage, there will be only two objections which will be considered by the court. First, whether there exists arbitration agreement. If the court prima facie finds that it may decide prima facie or finally. If the court prima facie finds that there exists an arbitration agreement, it will refer the parties to the arbitration and leave the question open for to be decided by the arbitral tribunal. However, the court has to decide one issue finally, and that is whether the agreement is void ab initio, that is null and void. Suppose there is an agreement, a classic example of say a rent act matter is referred to the tribunal. So it has no jurisdiction. So the agreement is null and void. Only that kind of issues will be considered at section 11. And then so the 8 and 11 is only this. So the immediately matter will go to the arbitral tribunal, and against the order of the court making a reference to the tribunal will not be appealable. No appeal would lie against that order. Appeal is provided only against the rejection to refer the matter to the arbitral tribunal. Then the section after the award,